All right, welcome to the video lecture for Chapter 11. Chapter 11 focuses in on the Sixth Amendment and is dominated by the idea of your right to counsel and the right to have a fair criminal trial. So the Sixth Amendment is usually not that familiar to students and the general public. The Fifth Amendment deals with fair trials and the right to a lawyer before and leading up to and during prosecution. The thought is that the Sixth Amendment serves as a protection against the government's resources by ensuring a fair trial. Now, the Sixth Amendment actually has multiple clauses. It has 7 separate clauses, one of which is probably the most well-known, speedy and public trial. The Sixth Amendment requires a speedy and public trial. So delays that harm the defendant's ability to proffer a defense can result in the charges being dismissed altogether. A delayed or prolonged trial is inherently unfair to the suspect. And with the presumption that you are innocent until proven guilty, you have the right to have that settled as soon as possible. Also remember, the founders came from England, where people could be held in prison without knowledge of their charges or without having a trial for years. So that was a huge harm that they wanted to see remedied by the Constitution and the Bill of Rights. Barker v. Wingo, 1972, the defendant was charged with murder and tried 5 years later after numerous continuances by the prosecution. And the issue here was the trial speedy enough under the Sixth Amendment? And the Supreme Court said, no, this is not a speedy trial. And to evaluate whether a trial is speedy or not, this is the criteria. How long was the delay? What was the reason for the delay? Did the defendant assert their right? Now, this is important. The defendant does need to assert their rights here. And what type of harm was caused? For example, if no harm was caused, then maybe a court is going to find that a fair trial still happened. But if the defendant's witnesses have died or moved away, if health issues have made it so the defendant can no longer assist in their own defense, those types of things are harms that were caused by the delay. So it's much more likely the defendant is entitled to relief there. Another clause in the Sixth Amendment is that you have the right to an impartial and representative jury. All crimes that involve jail time do not require a jury trial, though. More serious offenses, generally this is considered jail of 6 months or more, you're entitled to a jury. Part of the jury process is that voir dire is used. Voir dire means to speak the truth. And this is the process of questioning jurors about whether or not they're impartial. So jurors are frequently asked if they've been the victim of a similar offense, if someone close to them has been. Judges and lawyers are trying to root out those who cannot give the defendant a fair trial. Additionally, peremptory challenges are used to remove jurors. So all biased jurors can be removed. That's called a challenge for cause. Peremptory challenges can be used. Each side has a specific number, and it depends on the severity of punishment. So death penalty cases have the most peremptory challenges. Misdemeanor cases have the least. But you have a specific number of jurors that you can remove from the jury panel for any reason whatsoever, as long as it is not based on discrimination based for a racial, ethnic, religious, or sex-based reason. So you cannot use your peremptory challenge to discriminate, but any other reason you can remove jurors. The Sixth Amendment also requires the trial occur where the crime was committed. This is called venue. This is the geographical area where the case comes to trial, and this is also the area where the jury pool comes from. So the Sixth Amendment does require this, but it can be changed if there is such prejudice in the area where the case cannot be fairly tried with an impartial jury. It may be moved to more of an adjoining court. That's usually the remedy. A case could also be moved if there's a more convenient location for the parties and witnesses in the interest of justice require that transfer. Otherwise, though, and these are fairly rare, changes of venue are fairly rare. Most trials occur in the district in which they were committed. Next clause. The Sixth Amendment requires that you are informed of the accusation against you. Fairness requires that somebody know what they are being charged or accused of and charged with. So that has to be made known to the suspect. Also, as part of fairness, someone cannot adequately prepare a potential defense if they don't know what the charges are. All suspects also have the right to confront witnesses. In Michigan v. Bryant 2011, it did not violate the Confrontation Clause to admit a statement from a dying individual when there was no chance for the defendant to confront the witness. But otherwise, the witness needs to come into court or another situation where they are going to be examined by both parties, and the defendant has the right to cross-examine witnesses, the prosecutor's witnesses. There has occasionally been some controversy about the right to confront witnesses. Some states have tried to let witnesses testify behind screens and such. That is not acceptable unless the witness is a child who could be seriously intimidated by an abuser. At that point, a screen still can't be used, but maybe a one-way closed circuit TV or something else could be used where both sides can ask the child questions, but the child does not have to be in the same room with an abuser. So that does satisfy the Sixth Amendment. But we can't have people behind screens or things like that. Otherwise, though, in general, people need to be in court. And in Melendez-Diaz, a lab report was deemed testimonial evidence for this clause. So the technician needs to come in and be available for cross-examination and testify to the veracity or strength of the report. Now, we're going to talk about compulsory process next. This permits defendants to subpoena witnesses to court. This permits them to require these people come to court. If you do not answer a subpoena, there are going to be consequences such as jail time for the person who fails to appear. An arrest warrant may be issued, things like that. So this ensures that the defendant has access to witnesses who are favorable to them. Now, the right to counsel, this right is the only Sixth Amendment right that does not focus right in on the trial. This can go before and after the actual trial. So everyone has the right to legal representation, and every lawyer has an obligation to kind of zealously defend their client and ensure their client's rights are upheld. This is vital to ensuring that the defendant's constitutional rights are protected and upheld throughout the process, and that the defendant understands their rights and what they mean. We will spend a lot more time fleshing out this right to counsel. Powell v. Alabama in 1932, 9 young black youth, teenagers in early 20s, were accused of raping 2 women. And Alabama officials kind of quickly ran through all the court proceedings. They conducted a total of 3 trials that took 1 day, and all 9 of the defendants were sentenced to death. So they conducted capital cases in 1 day for 9 separate young men. And the question was, did these trials violate the Due Process Clause of the 14th Amendment? And the answer is yes. These defendants were not given a reasonable time and opportunity to secure defense counsels to assist them and protect their rights. So you cannot rush. As much as we need to have a speedy trial, you can't make it so speedy that the defendant doesn't have time to get a lawyer to protect their rights or be assigned a lawyer to protect their rights. Now, the next case in our progression here is Gideon versus Wainwright from 1963. Gideon was accused of breaking into, I think, a pool hall, and he asked for a lawyer and was denied, and he tried to represent himself, and Florida law only gave lawyers to those who were charged with capital offenses, while Gideon was just charged with a felony. And it's noted in the court record and in the opinion, if you read the full text, that Gideon did as good of a job as any non-lawyer could have done in his trial. And so the court held that the Sixth Amendment right to an attorney is fundamental to making sure a fair trial occurs. The right to counsel is absolute. Defendants must have an attorney or represent themselves pro se. But in all serious cases, any indigent defendant needs to be provided with legal counsel. And then in Arsinger v. Hamlin, 1972, we see the right to an attorney extended to defendants accused of misdemeanor offenses. So for the right to counsel, any crime that could result in a punishment that may include prison, the defendant has a right to a lawyer. So Arsinger his maximum punishment was 6 months in jail and a $1,000 fine. And he was entitled to a lawyer because he could have spent time in jail or prison. Okay. Now, your right to counsel extends beyond the Sixth Amendment. So you have the right to an attorney at every critical stage in the proceeding. So critical stages are any step where your rights could be impacted by the lack of a lawyer, by the lack of a lawyer's help and guidance. This is rooted in Messiah versus United States in 1964. A defendant pled not guilty and was released on bail. Co-defendant cooperated with police to record the defendant's incriminating statements. Did this violate his Sixth Amendment right? Yes. Even though it is acceptable and encouraged for law enforcement to continue to investigate, using a co-defendant to interrogate the defendant without his attorney violates the Sixth Amendment, and the statements are inadmissible under the exclusionary rule. So other critical stages are the identification process. So this is the procedures used to identify suspects by victims or other witnesses. This includes show-ups, lineups, and blind-ups. You have the right to have an attorney present during each one of these identification techniques. I'm not going to read the definitions to you because they're right here, but you have the right to have a lawyer present during any identification technique. This is a critical stage because if the suspect, the defendant, is not identified, then the case is likely over. In United States versus Wade and Gilbert versus California in 1967, 2 men were brought before witnesses to participate in a lineup without having their lawyers present, but after they were charged with the offense. And the legal issue was, did these men have the right to notify their attorneys? And the Supreme Court said yes. Pretrial lineups require that lawyers be present. Additionally, in Foster versus California, lineups cannot be arranged in a manner to make the defendant stand out in unnecessarily suggestive ways. For example, if a suspect is described as being very tall, and the lineup only includes one person who's very tall and everyone else is either short or average, that is unnecessarily suggestive. In Kirby versus Illinois, pre-indictment identification procedures are not a critical stage. So this is really important. If the suspect has been formally charged with a crime, and then the identification procedure happens, you have the right to an attorney. Period. It's very clear under the constitutional analysis. If the identification procedures happen before the indictment, before formally charged, there is not a right to a lawyer. So when the suspect is charged really is very important to determining if this is a critical stage or not, and whether or not the suspect's entitled to their lawyer. Other factors that are important to consider here are how reliable is the witness. So courts look at how long the witness had to view the defendant, the amount of attention the witness paid to the defendant, how accurate their descriptions were before they were made, their level of certainty in their identification, as well as the amount of time that has passed between the crime and the identification. So those are important things to determine how reliable, how much faith we can put in this witness's identification of this suspect as the defendant. Moore versus Michigan, 1957, establishes additional times where you can have your attorney present. So when you're submitting a guilty plea, you are entitled to have your lawyer present while you enter your plea. This is a critical stage in the process. There's a lot of information, and defendants need to know what rights they give up when they enter a plea. In Douglas versus California, the right to counsel is extended through the first appeal of right. So for your first appeal of right, you have the right to an attorney, but this is not an extended right. It's just for that first appeal to challenge the legal issues that arose in your case. Now, so we guarantee the right to an attorney, and we presume that your attorney is effective, dating back to 1932. So we look at whether the attorney's performance was reasonable. We look at whether to be ineffective, the lawyer must be undermined the proper functioning of the adversarial process, and the trial cannot be relied upon as having produced a just result. So an ineffective lawyer could result in a trial being declared unfit and the case being remanded back for more proceedings. So the attorney needs to be effective. Now, Sixth Amendment right to counsel, you have the absolute right to have an attorney for any offense that's going to result in jail time. You can validly waive your right to an attorney. Your waiver needs to be knowing, voluntary, and intelligent, and this dates back to 1988, which found that a Miranda waiver waived the Fifth Amendment but the Sixth Amendment right to counsel. The waiver does not need to be in writing, but it does need to be clear that the suspect is intentionally relinquishing their right and that it is a known right to them. When someone waives their own right, someone relinquishes their right to an attorney, they almost always decide to appear pro se. This is appearing where you represent yourself. Sometimes this happens because defendants just distrust attorneys, or they believe that they are better suited to handle their defense, or they're unable to afford an attorney, but at the same time they don't maybe qualify for legal aid. In Peremptory v. California, 1975, those who represent themselves must be aware of their right to counsel. They must validly waive their right to counsel, and they must be competent. So they must be legally able to move forward through the proceedings. Additionally, someone who proceeds pro se cannot later claim that they had ineffective counsel and receive relief under the ineffective counsel standards on appeal. Okay, so the right to counsel is very extensive here. If you have thoughts or questions, then please reach out. Now, juveniles in re Galt 1967, they also have Sixth Amendment rights. Those rights include, again, self-incrimination, the right to receive notice of their charge, confront and cross-examine witnesses, and the right to an attorney. So juveniles' rights are very similar to adults' rights in this circumstance. Within corrections, like the Fifth Amendment, the Sixth Amendment is not frequently used. When it does happen, is frequently based on the failure to have received a speedy trial in the detainer problem. So the detainer is when you file a document against another inmate who have criminal charges pending against them. So that if the Sixth Amendment comes up on appeal, that's usually how it comes up. Memphis v. Ray, 1967, convicted offenders have the right to assistance of counsel at probation revocation hearings in which sentencing has been deferred. The sentencing is a critical stage along with the arraignment, the preliminary hearing, identification procedures. Gagnon v. Scarpelli, probationers and parolees have constitutionally limited right to counsel on a case-by-case basis at revocation proceedings. So it depends on where the terms of the probation and whether it was deferred or not as to whether you have the right to an attorney at the revocation of parole or the revocation of probation. And the revocation means that the person will be returned to jail or prison. All right, so Sixth Amendment. By far the biggest issue here is the right to counsel and what that means. You do need to understand that it is triggered before the trial. It exists at all critical stages. It exists at the arraignment. It exists at the preliminary hearing. It exists at the plea. It exists at sentencing. It exists during the trial. And it exists at identification procedures if the person has been charged. I also think it's very important to understand the right to speedy trial and how we assess whether or not a speedy trial is being provided to a defendant. So we've covered a lot here. If you have any questions, please feel free to reach out.